All right. I'm very pleased to be here with you today. I am a copyright attorney, a trademark attorney, and this is an area of the law. I'll explain what this area is in a moment, which I enjoy practicing in. It's an area of the law where I can help my clients undo deals that they made when they were young, not necessarily foolish, but had no leverage. So copyright termination is something that shouldn't be overlooked by your accountant, your estate planner, you, or the person who ultimately is charged with managing your estate. Um, it's a powerful right. It really is a reset button. And when I say a reset button, it turns back the clock to the to the day when you controlled your copyrights. Unlike the Dramatist Guild in Dramatists, where there's a tremendous value placed on the author and the author's moral rights, as Deborah talked about, intent and integrity. Where the guild is fighting for you to keep as much of your copyright as possible. Most contracts in the entertainment industry, which I include the publishing industry, are for the life of the copyright, and that's a real long time. It's your life plus another 70 years, which winds up being, if you are so inclined and have children, which is really your children's children's children, perhaps. So when you enter into a contract, a license to uh, develop a property, a play, or say license the rights to make a motion picture, what purports to be a contract for the life of the author plus another 70 years is not so. It's terminable. So the message, if you walk away with nothing else, is don't believe anything you read in a contract. Thanks to the Copyright Act, there's a 5-year window that opens up 35 years after you enter into a contract or publication of your work that allows you or your heirs to terminate what I will assume is a bad deal entered into within the last 35 years. So one footnote to this conversation, where the rest of the week is what is going to happen after you are no longer here, this powerful right of termination to claw back your rights. You do not have to be dead. That is not a precondition. Your publisher doesn't have to be doing anything wrong. It allows authors to benefit from an extension of the copyright term that went from under what's called the old Copyright Act, which was in effect up until 1978. Under the old Copyright Act, works that were copyrighted prior to 78, the duration was 56 years. And later, in part due to the Sonny Bono Copyright Term Extension Act, ironically, and I'll explain later in my presentation, was extended to 95 years. That's for those really old copyrights. The copyrights from 78 onward are for your life in 70 years. Congress wanted you to be able to benefit from this bonus. In the case of, let's say, a contract that was entered into in 1964, maybe the Beatles signed something. I think Paul and George, the first contract they signed, which was a management agreement, not an agreement concerning copyright, but they had to have their father co-sign. Little Richard, according to his autobiography, was paid $50 for his song Tutti Frutti, which was an inducement for him to record it. And clearly, when you're young and the value, Ron was talking about valuation, the value of your work is not known or knowable, either to you or to your publisher or producer partner. Both of you are taking a gamble. So this is a way for you to send a notice, uh, uh, which is very formalistic, must be sent under very uh, strict time guidelines to your publisher or producer, whoever else has rights to your work. As long as the work is not a work for hire, the right of termination can't be waived. Even if there's a contractual provision which says you waive your termination right, it just isn't so. Um, so it's not only, as I said earlier, important for estate planners, but whoever is charged with continuing your business relationships after you're gone, those that existed during your lifetime, they need a working knowledge of copyright termination. Now, if not the guild that's taking care of your copyrights, whose mandate is to be sensitive to your authorial vision and your moral rights, it could be that your heirs who inherit this powerful right or obtain this powerful right under the Copyright Act once you're gone, they may have other objectives, which may be maximizing the return on your copyrights. I understand that Ernest Hemingway specifically provided in his will that his unpublished works would not be published. Well, guess what? They were, and to terrible reviews. The right of termination gives you and your families a mulligan, a right to do things over. So to understand the right of termination, I just want to go back and talk about copyright duration, because all these disputes, and there are lots of fights, litigation over what's terminable and what's not. Sometimes it turns on whether a work is a work for hire or whether it's an independent contractor who's just licensing you something. If it's a work for hire, whoever hired you is the author, not you. So that's why works for hire are not subject to termination. Before 1978, as I said earlier, copyrights subsisted for 56 years. They were divided into two 28-year terms. The second 28-year term was something you either granted to your publisher partner or producer partner or held back. Generally, both terms were licensed. If the author died before the second term began, whatever contracts he or she had entered into terminated, and notwithstanding what's in the author's will, these are with these older copyrights, notwithstanding what was in the author's will, his statutory successors, and when I talk about statutory, I'm talking about the Copyright Act, not the rules of intestacy, state law, were able to grab back the rights. So while a Tin Pan Alley composer might have left his copyrights to his mistress, if he died during the first term of copyright, his wife and children would be able to claw back those rights. I just want to give you an illustration or a way of thinking about this. It's not unfair to producers and publishers. Keep in mind that if you were John Steinbeck or John Steinbeck's publisher, when you acquired the rights to publish The Grapes of Wrath in 1938, it was Viking, which is now Penguin Random House. The copyright you purchased was for the economic life of that work, which was just 56 years. So depriving, Penguin Random House of 39 years of, bonus copyright that Sonny Bono was an author advocate, was able to get for dramatists and other authors, it just wasn't the heart of the matter. So I just want to make it clear that you have the right to terminate. And when you pass, your statutory successors, widow or widower, children, if a children or a child is no longer alive, their share devolves to their grandchildren. If none of the aforementioned family members are alive, your executor gets this right of termination. And if there's no executor, it's the next of kin. There's some peculiarities, and again, talking about the old act, but this is common to both recent copyrights and older ones. The termination right, except in that unique situation I talked about earlier, when a copyright owner died within the first 28 years, the termination right must be exercised by the majority of those who have it. Ray Charles had 12 children. 7 of them were incentivized to exercise their right of termination against a charitable trust that Ray Charles had set up for the benefit, and I found this curious, not for the benefit of visually impaired people, but for people who had hearing issues. He didn't feel that if you were blind or had impaired vision that you were handicapped, but if you had a hearing issue, it was something that he wanted to help you with. In that case, you had a majority, and the majority sent the notice of termination. First round of litigation, it was held that the trust didn't have the standing to challenge, and it went on to further litigation. And in the second round of litigation, they gave the trust the right to challenge, not the right of termination that the children had, but the very fact that Ray Charles didn't actually own the copyright. It was a work for hire, that his loan out corporation, a fiction that he contracted through, had him as an employee, and as such, the corporation owned the copyright, and the termination notice that his 7 children sent to his publishers and record labels was a nullity. Now, I don't know how this tale ended. As often happens, either the threat of termination or the commencement of litigation, it usually results in some negotiated settlement. So we don't know how this ended, but I suspect it was a negotiated settlement. But let's just for a moment say that the 7 children of Ray Charles were successful in terminating the copyrights that fed the trust. Royalty income was derived from those copyrights. Let's say those children were able to terminate. Even the children who were not signing the notice of termination would benefit. So they would be swept along. Of interest to older dramatists, under the old Copyright Act, pre-1978, in the case of joint authors, either author had the right to terminate their interest. Let's assume a lyricist and a composer, each under default rules of copyright would have 50% ownership and entitlement to 50% of the royalties. So any one of them or both of them could exercise the right of termination. Under the new Copyright Act from 1978 onward, you need both co-authors to join you. So if there's a book writer, a lyricist, and composer, 2 out of 3 are going to have to agree to terminate the copyright. So, what could be terminated? It's licenses and grants made by the author after December 31st, 1977. So here's a cautionary note. One of the one of, I guess, let's call it a sneaky lawyer trick or a sneaky music publisher trick, most commonly associated with music publishers, is for the music publisher, knowing that the right of termination is around the corner, to send the author or the author's heirs a new deal, propose a new deal. And while that deal may be attractive, it may not be the best deal that you can get if you're not aware that the reason they sent it to you is not out of the goodness of their heart, but because they wanted to get ahead of the termination notice. So the cautionary note I want to caution, I want to advise you of, is, be aware of what you receive in the mail or via email. If it's what's called a revocation and re-grant, which is a fancy way of saying the old contract no longer exists, the one that was terminable, because this new contract extinguishes it, be careful. That's the time to run to your agent and attorney and say, what's going on here? Just don't sign anything blindly, because you may be extinguishing that legacy contract that you have the right to terminate and then renegotiate or go to another publisher. You may be losing your leverage. So this right can't be contracted away. What's the outcome when a notice of termination is sent? It has to be sent somewhere between 2 and 10 years before the effective date of termination. Nobody is going to help you calculate what that date is. And this is something that attorneys check once, twice, 3 times, because the rules are so dense. But assuming that the notice of termination goes out and it's effective, it can interfere with testamentary freedom in certain instances. Licensees are cut off in the case of, let's say, a motion picture based on a play. While you won't be able to restrain the studio from exhibiting the work that they produced, you can prevent them from making further based upon or derivative works, which would include remakes, sequels, prequels, or licensing ancillary rights like video game rights. The usual benefit is the statutory successors negotiate a better deal for themselves. And again, that's the widow, widower, children, grandchildren, executor, or next of kin. Ronald was speaking about valuation. Copyright termination was a real blow in the film and music industry, as well as publishing industry, because in book publishing, for example, over 50% of revenue comes from backlist titles, legacy titles. So, well, though not your concern, but from a publisher's point of view, if they're buying a catalog of copyrights, it impedes the valuation. They need to calculate which works will fall out of their control and the like. The other limitation is the right of termination only applies to copyrights. So the musical adaptation of Les Mis, the authorial team can send, when the time is right, a notice of termination, but what will come back will only be their copyrights. And in the case of Les Mis, I can't get out of my mind the key art that was used to promote the show and probably is continued to be used to promote the show. So that falls in the heading of merchandise licensing. So copyrights come back, but not trademark rights. The rights that pass by will are, for the most part, constitutionally protected. There's a clause that says otherwise than by will in the Copyright Act. So, while naming your mistress and best friend in your will be recognized if you set up while you're alive a trust and put your copyrights in that. The trust would not be immune to termination. So you need to look at the intersection of copyright and trust and estates. If termination has not been exercised by the authors during the author's lifetime, and this is contested, notwithstanding the fact that the copyright interests passed by will and are bulletproof, are they vulnerable if the underlying rights, the actual agreement that the author entered into, the composer entered into with his music publisher, later becomes ripe for termination? So I'm not going to cast a vote, but just because you're passing a right by will, the rights to your copyright by will, it doesn't necessarily mean that at some later date, your surviving widow, widower, children who are unhappy with the shares they received or didn't receive under the will challenge your intent. We talked about works for hire. I talked about works for hire briefly. It's amazing. In the last month and a half, there have been, that I'm aware of, about 10 lawsuits that were either commenced or resolved. Marvel, actually Disney, just recently and within the last month filed 5 complaints for declaratory judgment that their agreements with their legacy artists and writers were work for hire agreements. The legacy artists and writers had sent termination notices, which is interesting. In 2013, Jack Kirby, the illustrator of the X-Men, Fantastic Four, Ralph Sevish knows this stuff better than I, sent termination notices to Marvel, and the matter was heavily litigated. And the determination was that Kirby was not an independent contractor, that he was an employee for hire because Marvel had the ability to control and assign works to him. Likely that round of termination notices sent by 5 writers or illustrators will fail, at least the ones that fall under the old Copyright Act. I want to also mention, and maybe I should open this up for questions, Deborah, let me know.
We do have quite a few, so I want to hear what you have to say. Though you were about to say something.
Okay, so let me try and wrap this up about what's not terminable. If you're late to the party, if you don't act promptly, it's a lose it or use it situation. You can't file too early and you can't file too late. The law is unforgiving on all these technicalities. It does not apply to foreign works. And as I said earlier, derivative works, a film made from your play, you can terminate, but they are allowed to continue to exhibit the film they made under the terms of the contract you agreed to, but they can't have remakes or whatever else was agreed, what other derivative works were agreed to under the original contract. Probably that's a good place to stop. I could go on. Well, I did say that it was ironic. Maybe this is the place to end my discussion. On October 14th, Cher of Sonny and Cher fame, Sonny, as I mentioned earlier, when he was a congressman from California, was responsible for the Copyright Term Extension Act, which extended terms by 20 years. Sonny's fourth wife filed termination notices and tried to upturn or overturn a marital agreement that Sonny and Cher entered after their divorce. Under the settlement agreement, Cher was to receive 50% of royalties generated by Sonny Bono's copyrights. And the case is to be decided. Cher, when she filed the notice of termination, she wasn't challenging their right to terminate all of those publishing contracts, music publishing contracts, but she was saying that her right to royalties continues. It's not a copyright, it's a contract right. And we'll leave it at that.
So I'm just going to jump in because we have a whole bunch of questions just to stay on topic, and then we'll probably end up asking questions about the first little bit too. But somebody's asking that it sounds like you can't use a trust in your estate planning then, because you might end up losing your termination right.
Ron can speak to this, but if it's an inter vivos trust, right, Ron, that's outside of your will. If it's outside of your will, that's vulnerable. If it's a pour over, maybe not so.
Yeah, I don't really have anything to add to that.
Maybe something to bring up to your attorney.
Yeah, sometimes trusts are opted for over a will, and that can present a problem. Yes.
Okay. Somebody's asking, Margaret's asking, if my work doesn't have a clear track record of sales, how would it be appraised?
Right. So some of the questions on there about, there's no royalty streams, there hasn't been any activity. Well, then it makes the appraisal much harder. But you're really looking at, what earnings potential there is, and you're looking at what's known and knowable at the time. So if someone has a musical that hasn't been, produced in 15 years, and there's no stream of income coming in or no contracts to market that again or exploit that, probably doesn't have any value. I'm not an appraiser. I'm not going to say that for sure, but they're going to look at, what's out there. And if it's not generating any income or any revenues, there's nothing on the table at the time when you're looking for the valuation, it's probably going to not have anything more than a nominal value.
And relatedly, somebody's asking who exactly is hired to do the valuation? Is that a special type of accounting or?
Right. So there are different valuation firms. You need to have a qualified appraisal that has all the necessary designations. Markham does appraisals. We do a lot of appraisals for authors and people that have literary works upon their death or for gift purposes. So an accounting firm can do that. There are appraisal organizations out there. I'm sure if you do some Google searches, you'll find all the appropriate people that can do that.
All right, we have an anonymous attendee asking, can you talk about the specific things you need to do to use the termination? So I know you said you had to issue notice and it was rather dense. Most of the attorneys are looking up the dates, but is this something that someone could even do on their own?
No. And I'm not looking for more work, but I would recommend that you seek the help of a qualified copyright attorney. What you need to do is you need to know when to send it, to whom to send it, in what form. And in some instances, it's the date of the contract that controls. In some instances, it's when the work was published that is how you calculate. Then you have the option to send it early, 2 years by the date of termination that you've selected, or 10 years in advance. So there are lots of traps for the unwary. If it's a valuable asset, it's not something that you want to try and do yourself. And actually, not a lot of attorneys want to do this because of the liability issues.
Uh, Interesting. Should I be putting my property into an LLC to avoid taxes, estate taxes?
I'll answer it from Ron, just from a copyright perspective. They're, affectionately known as loan-out corporations in the entertainment industry, where you're an employee of your company and treated like that for tax purposes. What that does is it extinguishes your right to exercise a termination right. So from a copyright perspective, that's my answer. Ron has a different way of looking at it, I'm sure.
Right. Well, I can't really answer the question with respect to literary properties because of all these complexities that are involved. But typically putting an asset in an LLC and then gifting away minority interests will allow you to take advantage of the discounts that we talked about for lack of marketability and lack of control, because now you own an interest in an LLC and the LLC has an operating agreement that says, if you want to dispose of your units, you have to offer it for sale to the other members and you can't sell it to third parties. So LLCs are generally good ideas with respect to reducing the value of an asset that's in your estate. I can't really say how it works with respect to royalties and intellectual property.
It sounds like you almost have to go, it's a balance, really, choosing what you want to happen along the way. Somebody's asking about the $11 million exemption. And it sounds like they're confused as to if they could do something now to make sure that they're collecting on that 11 million. Is there something they could do now to make sure the 11 million sort of stays with their estate, or are you subject to whatever rate when you die?
Well, your exemption, if you have assets that are over $11 million and you don't do any planning today and it goes down to 6 million, you lose the benefit of the 5 million because under the new tax proposals, they reduced it from almost 12 down to 6. So you're going to lose that 6. If you have more than $11 million to give away, you have $50 or $100 million, and you give away your 12 million, and then the exemption goes down to 6, you haven't lost anything because there are no clawback provisions that would cause you any adverse tax consequences. And when you give away things today, when you die, the value that's includable in your estate is the value as of the date of the gift. So by giving away something today and using your exemption, it keeps all the appreciation out of your estate, for all the future years.
Got it. Somebody's asking about the slides. The slides are actually posted on our website, so you can go check them out. The link is in the chat. Colin is asking, I was left 2 copyrighted plays in my will. So they're now in a will. So they're now my property. So he owns 2 plays that were written by somebody else. Do I have the authority to manage those properties, including making any changes to them if that was not specified in the will? They're not published and they have not been produced. No contracts are associated with them. What should I also put in my will to protect or exploit these properties after my death?
Right. So I saw that question. I really don't. What I'm really talking about is things that you as the decedent or the creator should do for disposing of your interest. I don't know, Lloyd, if you have any idea of how that would be affected if you were giving away something that someone else created and you inherited, what rights you have with respect to that. I would assume you'd have all the rights because you own it, right. And you'd step into the shoes of the person who gave it to you. But I don't know for certain if there's anything that would restrict that.
So what would restrict, that's correct. What would restrict it is the termination right that the statutory successors under the Copyright Act may have. So if the individual who was the beneficiary of those copyrights was a friend as opposed to a blood relative, there is some risk that that could be yanked out of the estate, but the risk seems minimal if it's not a highly valued work. Okay.
Michael's asking if your LLC LLP is not part of the estate, is it possible to trade shares of the LP? Or can shares of the LLC be gifted? I'm not sure about the amount of control and tradability. So can you?
Well, not really clear on the question and what's in the LLC, but if you own an LLC, you can gift units in an LLC typically. And that's why there's a benefit to that, because you're going to give away something that's less value than the in total underlying assets, because it's not marketable and you don't have control over it. So not really sure about what it's not includable in your estate or what you're trading with, but typically you would want to give away LLC interest because you can get these discounts.
Got it. Somebody was asking if there were liabilities associated with the termination rights. I'm not sure I'm fully understanding that, but Lloyd might understand that.
Well, yeah, the answer is yes, because when you send a notice of termination, it's not just an invitation to a negotiation. It might be seen as an invitation to litigation. And, litigation, whether it's meritorious or not, can be costly. The danger is somebody may seek a declaratory judgment, saying that I own it, you don't. Several weeks ago, one of the composers of KC and the Sunshine Band filed a declaratory judgment asking a judge to tell the music publisher that their termination notice was valid, because they were saying, pound sand. They got the notice, but they ignored it. And it's possible that somebody can say that there's a provision here that says, if you challenge our rights, bad things will happen to you. There's a penalty of X number of dollars. Generally thought that those penalties are unenforceable as a contract that is trying to rewrite this inalienable right. So, I mean, as an attorney, I'm always looking at the glass half empty. So those are the things that can keep you up at night.
And just somebody's asking again. I think you touched upon this about termination. Can I terminate if my co-author does not terminate? And I guess we always make the distinction at the Guild too between something that might have been a joint work or something that where like the different parts were sort of registered separately and owned separately. So can you make a distinction between those two?
Yeah, no, it's an excellent point. So let's just set aside whether it was prior to 78 or after 77. Let's say it's present. It's present day. If the book writer contracted separately for their services, and the composer and lyricist contracted separately for theirs, you'd have two separate contracts, with three separate contracts with a third party, I guess would be the producer. Each one of those could be terminated because there's only one signatory, one rights holder. Just following the thread, at some point, all three merge, but that doesn't extinguish their individual contributions. So you've created a new copyright in a derivative work, and then you would need two of the three copyright holders to terminate the joint work. So it's a lot like chess, point, counterpoint. But generally, and I don't know if this answers your question, if it's present day, both co-authors have to act together if they are indeed considered joint authors, as opposed to just independent contributors whose work is being plugged into something larger.
And somebody is also asking if we wanted to read more about this, are there relevant cases that sort of are surrounding this like joint work topic that have come to light?
Yeah, let me think about it. There's the Childress case.
Mm-hmm.
I think it's the
well, that's the work, that's like authorship.
Authorship, right.
Right, but are there cases relating to termination that have come through?
Yeah, there's a case recently, when I say recent, within the last 5 years, concerning the song YMCA. And the music publisher challenged a notice of termination that was submitted by one of the composers or contributors to the song. And he won, they lost. They had argued that you needed a majority in order to terminate. And what turned out to be an odd case, since he had a freestanding contract, just him, he was able to terminate his share. So it sort of loops back to what we had said earlier. If they contract with the lyricists from the book writer, either when the time comes, we'll have an opportunity without the other to send a notice of termination. And under the old act, it doesn't matter. Either one has the right to terminate their share.
Wow. So much. I'm just looking at the questions. There are a few more questions. I think some of these might be better posed to, questions about joint work and copyright registration should really be directed to the business affairs line. I kind of want to keep us more on topic, and I also have to let these gentlemen get back to their day jobs because they were gracious enough to stop their day at 3 o'clock. Somebody's asking about the email we sent out when we asked for questions on reversion, why we said that somebody could have, there could have been a Broadway show and the person get cut out of the profits. The answer to that is if you sign a publication deal and you inadvertently don't exclude your first-class rights from that, then the first-class rights would be included in that, and therefore, Sam French or whoever would be negotiating on your behalf as they would for any community theater or stock and amateur production that you might have. So that is exactly the type of thing we would want to claw back and call an attorney and get some help on. So with that, thank you both, Lloyd and Ronald, for being with us today. I think this was
Thank you.
Tremendously informative and, a deeper dive into something that we don't often get to discuss, and eye-opening. And it's made me a little confused. I have a lot to learn, but if anyone else is with me, we'll continue to learn together. So thank you both for joining us. And again, anyone interested in the informational session at 6 o'clock, feel free to join me for that to learn more about DGCM. Otherwise, I appreciate everyone's time. It's been a long week of estate planning. We've had seminars all week long, and this was certainly an incredible way to end. It makes me realize that we will probably have to have a part 2 next year for National Estate Planning Week as well. So thank you so much, Lloyd and Ronald, and
Thank you.
everyone else. Thank you for your time. We'll see you all soon.